Item number 1.
Yes, Dr. Bozika.
My lords.
Both of you are ready?
My lord.
All right. Pass over.
Item number 2.
Ready?
Ready?
Yes, my lord.
Pass over.
Item number 3. Number 3.
Lordship, I was informed by the petitioners that the conducting counsel is indisposed.
You are for the respondents.
I'm for the respondents, Lordship.
Don't to pray for adjournment for the other side.
My apologies, Lordship. I was just informed. Since no one is appearing on behalf of the petitioners.
None appears for the petitioner. No accommodation is sought. The respondents are represented by learned counsel. Next, we adjourn this writ petition till 25th June. If on that day none appears for the petitioner, you're for the petitioner.
Yes, lordship.
Then why are you not responding?
I was in the.
You
other
are
court.
ready with the matter?
Your lordship, I prefer Germany, lordship.
Why?
Arguing counsel is not keeping well, your lordship.
Who's the arguing counsel?
Mr. Philemon Ongpri.
Can you strike that out? So and so appearing for the petitioner, learned advocate appearing for the petitioner, prays for adjournment on the ground of illness of his senior. The respondents are represented by learned counsel. This writ petition is adjourned till 25th June.
Lordship.
Full stop. No further adjournment will be granted.
Lordship. Oblige, your lordship.
You oblige.
Second call. Item number 1.
Yes, please.
My lord, I prepare a sequence of events, my lord, for lord's convenience, my lord.
Let us see the impugned judgment,
My lord.
page 139.
My lord. But if I before going to judgment, my lord, the learned single judge has by and large agreed with my submissions, my lord, and asked for continuance of the inquiry that was going on against him, my lord.
Yes.
But only part we are agreed with is that learned single judge is directed for his reinstatement, my lord. Now, in paramilitary forces, my lord, if somebody is on unauthorized leave, my lord, there is no scope for his reinstatement, my lord, for conducting an inquiry. That is the only part we are agreed with. The last paragraph, if I may just take your lordship, my lord. If I may read from para 10 onwards, my lord. I will read from para 9, my lord. At page 144.
Where is the order for reinstatement?
Well, para 11, my lord, seventh line, my lord. It starts with, it is open to the respondents either to reinstate the petitioner and conduct the inquiry or place him under suspension and conduct the inquiry.
He is under suspension.
My lord, what happened? He went on deputation to National Police Academy, Hyderabad, my lord. We released him on deputation, my lord. Thereafter, for 10 long years, my lord, on one pretext or other, and he started filing cases in Andhra Pradesh High Court, my lord. And there was stay orders operating, so he never came back to Assam Rifles, my lord. So ultimately, he lost all the writ petitions and writ appeals before the Andhra Pradesh High Court.
No, what is the service position? Dismissed.
My lord, he stands, because what happens, my lord, in paramilitary forces is somebody does not join, my lord, in service. He goes on leave for a month, does not come back, my lord. He is declared a deserter. And he is dismissed
No,
from service.
he's been removed from service.
My lord, in a sense, he is not in service of Assam Rifle as of now, my lord.
You see, here the learned judge has made a slight mistake in application of service law. When there is suspension,
My lord.
the service remains,
My lord.
but he is suspended.
My lord.
So the judge can say that revoke suspension, conduct inquiry.
My lord.
The service is not terminated. But here the case is that under whatever rules,
My lord.
the service has been terminated. So reinstatement
My lord.
tantamounts to allowing the writ and quashing the inquiry.
My lord, let him finish one. Here the question, my lord, court of inquiry was never conducted by the respondent authorities, my lord. Still, my lord senior is saying that it's continuing, court of inquiry. Court of inquiry was
You
not,
have not preferred the appeal.
my lord,
You have not preferred the appeal.
no, my lord,
He has preferred the appeal.
my lord.
Only on one point. That is reinstatement.
My lord, if the court of inquiry would initiate, my lord, then the question of, my lord, the learned single judge has also said that the court of inquiry should be completed within 4 months.
That we will say, yes, it's okay.
My lord.
He's not aggrieved by that. But a reinstatement is a procedural problem.
Well, our case, my lord, if he is successful in court of inquiry, if he is exonerated, my lord, he will be taken back in service, my lord. That's
But now he's not paid any allowance.
no, my lord. He is not paid anything, my lord.
My lord, since 2010, my lord, 2015, my lord, similar case, my lord,
The
petitioner,
learned judge has granted 4 months' time.
my lord,
My lord.
That is over.
That is over. That's why we filed an appeal. I think there is some interim order. So I'll just. Well, what I'm praying, my lord, only that part is interfered with by a lordship, and for the same 4 months' time is granted. Well, will you conclude
it is,
inquiry?
my lord, how
You have,
much,
not, you have not begun the inquiry up to now
Well, no.
because of this order.
Well, our case is only if he is exonerated, then only he will be entitled to reinstatement, my lord, not at this stage.
my lord, if I take you, my lords, to page 28 of the paper book, my lord,
You see, this order,
my lord,
page 139, was passed on 5th March 2024
my lord,
by His Lordship.
my lord,
1.5 years
already,
have almost elapsed.
my lord,
Wait for 4 months.
my lord,
You have not been reinstated. Let the inquiry be completed. Instead of 4 months, we will make it 3 months.
Well,
my lord, it will be I appreciate whatever my lord has said. What the learned single judge has also stated, my lord.
Because nothing can be more in your favor.
My lord,
The order is completely in your favor. Anything else would be against you. Any other submission. But still, if you want to say something, please do. We will not stop you.
my lord, since 2000, my lord, can come to page, my lord, 17, my lord. Just whatever my lord has, 2007, page 17, my lord.
Yes.
My lord. This was also the judgment of this learned single judge, wherein also, my lord, this honorable court has also directed to conduct the inquiry, my lord. To conduct the inquiry, my lord, page 28, the operative part, my lord.
Yes.
Para 11, my lord. Since then, my lord,
My lord, Lordship kindly see the last sentence of this order, my lord. This is exactly what I am submitting, my lord. If he is found innocent, he is to be reinstated after the inquiry, my lord. Now, in the subsequently, the learned single judge has said first to reinstate and then conduct inquiry, my lord. My lord, see in the last sentence, my lord. Directed to conduct a fresh proceeding against the petitioner if the department desires so, as per Assam Rifle Rules 2010, Assam Rifle Act 2006, and if he is found innocent, he is to be reinstated forthwith with all areas and other things. So conduct an inquiry. If he is found innocent, reinstate him, my lord. That was the direction in 2015, my lord. Now in 24, the learned single judge has directed first to reinstate, then conduct the inquiry.
Oh, this is regarding the same person.
Same person, my lord. And this order has attained finality, never challenged, my lord, by anyone, by them also, my lord.
What was the impugned order dated 22nd?
that was declaring the petitioner as a deserter, my lord. Absence without leave.
Here your client did a mistake. When the order of desertion,
My lord.
when
That has been set aside, my lord.
second of 20, This is dismissal on the ground of desertion.
my lord.
Well,
Now, when this order was set aside, at that time you should have asked for an order of reinstatement.
My lord, that was the mistake, admitted mistake by the, that was the different counsel, my lord.
It may have been followed by another suspension
My lord.
inquiry.
My lord,
But
for the
this
last,
order which has attained finality,
my lord,
desertion order is set aside.
my lord.
But the termination of service, removal from service remains. There is no order for reinstatement because the learned judge says that you conduct the inquiry.
My lord.
If found innocent,
My lord.
then reinstate.
My lord.
That means desertion set aside, but no reinstatement. So how can the court reinstate him now?
My lord, to conduct the inquiry for last a decade, my lord. Till what time the petitioner?
All right, we will have reached the time since because of this they have not conducted the inquiry.
My lord,
We will
they-
make it 3 months.
My lord, there was no stay as such of this order, my lord.
What?
And there was nothing, no stay, my lord. What they have done, my lord, of the previous order, my lord. For last 10 years, what they have done, they have initiated any court of inquiry, my lord.
well, the stay orders operating from Andhra
No,
Pradesh
ma-
High Court, my lord.
No.
My lord, I've mentioned
Whatever they have done or not done,
My lord.
the second writ went before Justice Vaidyanathan. That point was not raised there. That has attained finality. That you conduct the inquiry, finish it. There is no comment, observation about not initiating inquiry proceedings, but simply finish in 4 months and reinstate. They are agreed by that part. Now you understand the problem.
My lord.
He was sent on deputation to the police academy.
my lord. Well, he went on initial deputation of 2 years, my lord.
3 years.
And this gentleman is from Andhra Pradesh, my lord. So he tried to get absorbed in police academy in Hyderabad, my lord. And
When he was sent.
but he went on deputation in 2005, my lord. Then when police academy did not want to absorb him, my lord, he filed a writ petition in Andhra Pradesh High Court for absorption. There were stay orders operating from the Andhra Pradesh High Court, my lord. Finally, the writ petitions were dismissed. Then, my lord, so somehow he was forced to come back, my lord. Then for that, there's a movement order has to be issued by police academy, my lord. So another round of writ petition was filed before the Andhra Pradesh High Court. So those are not relevant at this point of time, my lord. But the fact remains that he filed several rounds of litigation before the Andhra Pradesh High Court for absorption in police academy, my lord. When that was denied by the Honorable Andhra Pradesh High Court, my lord, then he second round of litigation for allowing him to come and join Assam Rifles, my lord. Even that was rejected by the Andhra Pradesh High Court, my lord, finally.
Do that within 3 months. The appellant stroke writ petitioner was employed with the Assam Rifles. In 2005, he was sent on deputation to the Police Academy, Hyderabad. Paragraph. after this term of deputation was over, he was recalled by his employer. But he did not do so. The Assam Rifles being a very specialized and disciplined force, he was treated as a deserter and dismissed by an order dated 22nd August 2010. Dismissed stroke removed from service. Aggrieved, he preferred a writ petition in this court, bracket WP, bracket C, number 72 of 2013, bracket closed. R. Ramu versus the Union of India and others. Stop. It was heard before a learned single judge. Stop. By a judgment and order dated 5th May 2015, he disposed of the writ petition by setting aside the order dated 22nd August 2010 and directing quotation, if the department desires, unquote, fresh disciplinary proceedings according to the Assam Rifles Rules 2010, framed under the Assam Rifles Act 2006. Full stop. Quotation. If found innocent, unquote, he was to be reinstated in service. Next, examining this order, we find that although the order of termination of service of the appellant writ petitioner was on the ground of desertion was set aside, he was not reinstated. Full stop. His employer was given the option of conducting a fresh inquiry and reinstating him if they found him to be without fault. Paragraph. This inquiry according to the respondent writ petitioner was not made according to law. It was started.
No,
Huh?
never.
This inquiry was not started according to the respondent writ petitioner. He filed a second writ in this court, WP bracket C number 323/2015, R. Ramu versus Union of India and others. It was disposed of by a judgment and order dated. It was disposed of by a learned single judge by a judgment and order dated 5th March 2024. Directing commencement and conclusion of disciplinary proceedings, stroke inquiry. Inquiry within petition. Within 4 months of pronouncement of the order, by either reinstating the respondent writ petitioner or placing him under suspension. Paragraph. The appellant has accepted that part of the order directing inquiry, but is aggrieved by the portion directing reinstatement or suspension. Here, paragraph here, as pointed out by Dr. Muzika Learned, Deputy Solicitor General, appearing for the appellant, the learned judge has fallen into error. Paragraph. By the judgment and order dated 5th May 2015, in the first writ, this court consciously, after setting aside the dismissal stroke removal from service order, did not reinstate the respondent writ petitioner, but subjected such reinstatement to his being found guilty in an inquiry to be made at the option of the appellant. Full stop. This order has attained finality. After 10 long years, when the second writ was disposed of on 5th March 2024, the issue was regarding speedy conclusion of the disciplinary proceedings, stroke within quotation inquiry. Full stop. There could not have been any question of reinstatement at that stage. When for 10 years the order refusing reinstatement after attaining finality has remained in force. Moreover, in departmental proceedings where the service of the delinquent has not been terminated and is intact, but inquiry is being conducted against him or her, the court if it finds the court may direct the employer to allow the delinquent to work by revoking his suspension or by any other direction. Full stop. Such kind of reinstatement in service, within quotation, is permissible. But when an employee has been discharged from service, reinstatement pending conclusion of inquiry would tantamount to quashing the inquiry and allowing the writ. Paragraph. In those circumstances, we set aside that part of the impugned order dated 5th March 2024 directing the appellant to, within quotation, reinstate the respondent writ petitioner or conduct the inquiry by placing him under suspension. and affirm the rest of the judgment and order, comma, with the modification that considering the passage of time, the inquiry should be concluded with a final decision in respect thereof within 3 months from date, after complying with the relevant rules and the rules of natural justice. This appeal is accordingly disposed of. By modifying the impugned judgment and order dated 5th March 2024 to the above effect.
Deeply.
Number 2.
Where is this? What is this MC? Pending. MC 32 of 25, MC 134, etc. are also disposed of.
This matter, my lord,
Yes. Yes.
well, page 169 is the operative part of the judgment, my lord. 169. Para 10. My lord. Start.
The learned judge says that it should be applied to doctors, but not to nurses. Paragraph 8.
Well, our rules say, my lord, that the doctors are exempted from this, my lord. If doctors, even if they have LASIK surgery, my lord, they can be appointed. That your lordship will find at page 133, my lord, of the paper book. 133.
What is LASIK surgery?
It's a eye correction, my lord. If somebody does LASIK surgery, my lord, they don't need to wear the glasses, my lord.
Correction of eye vision, my
Correction
lord.
of eye vision.
Yes.
Page 133, lordship will find, my lord, rules 67, my lord, para 67. It says refractive surgeries. Candidates who have undergone LASIK, laser in situ so and so may be considered fit for recruitment for the post of direct entry gazetted officers. So, in terms of the rule, the gazetted officer, the doctors are gazetted officers, my lord. So they can have LASIK surgery, my lord. Page 112, my lord. Lords, page 112, my lord. The table, my lord, table 3, the lower one at the bottom, my lord. There are two tables, my lord. I'm referring to the table below, my lord, table number 3.
Yes.
Now, my lord, this says, my lord, visual standards for direct entry. SO means, my lord, subordinate officers, and OR means other ranks, my lord. Subordinate officers and other ranks in Central Armed Police Forces, NSG and AR. My lords, you will see a column refraction, my lord, in the middle, somewhere in the middle, my lord. It says visual correction of any kind is not permitted even by glasses. So, my lord, visual correction by even by glasses or LASIK is not permitted in case of subordinate officers and other ranks, my lord. But it is permitted in case of gazetted officers, my lord.
You cannot wear glasses also.
The subordinate officers cannot, my lord. At the time of recruitment, my lord, these are the, if I may take, these are the recruitment medical guidelines, my lord. Page 46, it starts, my lord.
Assam Rifles.
It is for all paramilitary forces, my lord. The title is at page 46, my lord. Guidelines for recruitment medical examination in Central Armed Police Forces and Assam Rifles. Page 46, my lord. So these apply all across the paramilitary forces and Assam Rifles, my lord. What learned singles has held, my lord, that this is discriminatory towards the nurses, because nurses are other ranks, my lord. They are lower category ranks. So learned singles has held even doctors are allowed, why not nurses? They are doing the same kind of job in the hospitals, my lord. My lord, out of 3 directions in the operative part of the learned single judge order, my lord, we are aggrieved. Para 2, we don't have much to say, my lord. The learned single judge directed us to reconsider, conduct fresh medical examination. That may be a lordship. I'll leave it to lordship discretion, my lord. The direction in para 1, setting aside rules, clause 67, my lord, and the direction in para 3, my lord, that it is made clear that without appointing the petitioner as staff nurse, no other nurse shall be appointed. This has a blanket effect on restraining all the appointment of nurses all across India, my lord. And our case is, my lord, classification on the basis of reasonable classification is permitted, my lord. The higher posts, my lord, the gazetted officers are higher posts. So and that is why they are permitted, my lord. The lower ranks are not permitted. But the learned single judge tried to classify vertically, my lord. Learned single judge is not held, my lord, because Assam nurses is just one post, my lord. There are compounders, there are fitters, there are electricians, whether the same category of post, my lord. The learned single judge only found in a vertical setup, my lord, that because doctor in hospital is allowed, nurse should be allowed. Whereas the classification is horizontal, my lord. We are saying that this particular category of post will not be allowed. this category of post horizontally will be allowed, my lord. So all gazetted officers, my lord, whether they are doctors, they are gunmen, they are soldiers, my lord, if they are gazetted officers, they are permitted, my lord. It is not only a case of doctors, my lord. Because the effect of this order will be, my lord, if nurses in grade 3, my lord, are allowed with LASIK surgery, that means drivers also have to be allowed, my lord. The riflemen also have to be allowed, my lord. But then it will amount to that.
What other categories of employees are there?
My lord, we have 18 type of technical posts, my lord, in Assam Rifles. Compounders, my lord. Radio diagnosis. There are drivers, my lord. There are electricians. There are nurses. So overall, there are 18 types of posts, my lord. And again, there are ranks in all kind of posts, my lord. And the last one is general duty, who are the soldiers, my lord. So there are ranks in all categories, my lord. Even the soldiers, even the doctors, nurses, my lord. So nurse also, if she is appointed to a gazetted post, my lord, she will be permitted. But she will not be permitted in the lower rank, my lord. The learned singles is mixed up in, if I can use
No,
that
but
word.
what entitles a person to be gazette notified?
But certain posts beyond those are gazetted posts, my lord.
No, but it has to be some rank.
Rank, my lord. I believe the post from captain onwards, my lord. Captain upwards are gazetted posts. Captain, major, lieutenant colonel, colonel on the higher post, my lord.
Is there any rank in the service of nurses?
Yes, ma'am.
What is the rank?
Well, they start with rifleman. They start with then the lower category, my lord. Riflemen, then they'll become havaldar. Then
Nurses.
my lord. These are all combatite posts, my lord. All have to undergo military training, my lord, in Assam Rifles. Even the nurses, the doctors also. And they wear uniform also. Lordship, any further query, my lord, I can call the officer tomorrow. Lordship, it takes up tomorrow.
Well, the officer will not do this. Central. This is from Delhi. Delhi. What he will do?
Because our case, my lord, primarily is that we have done classification horizontally, my lord. The gazetted officers and below that are not permitted. Certain rank is permitted, my lord. The learned single judge has read it vertically, my lord. That in medical establishment, because doctors are permitted, nurses should be permitted, my lord.
Otherwise, it is ridiculous.
My lord.
Nurse has to be excluded. You cannot include them. You have to give a rational meaning, application. Those who are part of the force will be for the real function or the main function of the Assam Rifle Force is defense-oriented function. Those who are directly involved in defense, eyesight problem will not do because you need to hit the bullseye. But those who are in ancillary kind of service, hospital, nurse, this and that, you can't apply a military man's rule to them.
Because why it is because they are all competized, my lord. Even they are appointed as nurse, my lord. They have to undergo same military training. They have to undergo
where you have written subordinate officers,
my lord.
excluding nurse, etc., etc. This one bracket is required. Those who are going on the field, subordinate officers, of course, you need absolute perfect eyesight. But officers, yes, they are sitting in their room, sitting at the table, or giving instructions from the table. That is why this distinction is made: gazetted, non-gazetted.
My lord, why I am submitting, my lord? Because all posts are competized now, my lord. So even if a nurse or an electrician, my lord, when they join Assam Rifle, they have to undergo compulsory military training, my lord. Same rigorous training is given to. They are trained in arms, my lord. Even the doctors and nurses, my lord. And they wear uniform, my lord.
Arms, how will they use arms?
A training at the time of recruitment, same training is given to them, my lord.
But their duty is in the hospital.
Primarily, my lord. But in case of emergency, they are called upon.
That's all right. But then their eyesight is not the main criteria. When you are Running, chasing, shooting, eyesight, yes. Identifying, attacking the culprit from a hideout, eyesight is very important. But the doctor can wear a spectacle, but the nurse cannot wear a spectacle or even go refractive, has to have perfect vision.
Because then what will happen, my lord, the difficulty that we will face, my lord, at the same level, my lord, the nurse is one category of post, my lord. There are, for example,
The problem is those your officer staff cannot think holistically. They are bound by those rules, computerization, categorization of posts. They don't know how to get out of it. We will help them.
my lord, why I'm submitting, my lord, clerk is one type of post, my lord, one category. There are other several drivers are there, my lord, electricians are there. So if you lordship hold that nurses are exempted.
Okay, we will say that without prejudice to any right and contention, writ petitioner you take. And thereafter, you consider amending these rules.
My lord.
Yes.
One person you take, we will not block the whole thing.
My lord. And para 1 and para 3 is subject to consideration by the government, my lord. They'll relook into this, my lord.
No, we will keep this matter tomorrow.
My lord.
We will hear it out a little more
Well.
and then pass the order.
My lord.
Madam. With Lordship first, thereafter with Justice Patel. Heard and adjourned till tomorrow. List is appealed as the first appeal in the list marked as part 2. You also give it a considered thought and come back.
Well,
All right.
this is a little tricky, my lord.
Because this, just a bracket has to be inserted, not to include certain categories like nurse or say a cook, something like that, whose eyesight is not a issue at all.
Well,
But driver, yes.
deep.